of the state of Michigan versus Cody Lee Gillis, 231249. And appearance for the people, please.
Alexander Kirker on behalf of the people.
And counsel, your bar number, please.
Scott Nadeau, P64316.
Hold on, Mr. Nadeau, just one moment. Mr. Kirker, your P number, please.
P86282.
Thank you. All right, yes, Mr. Nadeau.
Yeah, Scott Nadeau, P64316 on behalf of Mr. Gillis.
All right, Mr. Gillis, your name, please, for the record.
Cody Gillis.
All right, well, today's date scheduled for an in-person exam. The court's going to note for the record that Mr. Nadeau emailed this court on Monday, I believe it was Monday, but we were closed for the holiday. And so we received this Tuesday morning and indicating that it was, that your client was unexpectedly called out of town and was not going to be able to be present.
That's correct.
And so then this court requested some proof of the reason why Mr. Gillis wasn't able to be in person for court and was told that that was not possible.
Yes, I believe it's an injured old lady, and it just seemed inappropriate for me to ask him to provide proof of that. I just, they're going through enough right now.
And I understand that. But this court, I can understand that you may think that that's inappropriate.
Right.
I, however, do not, which is why I ordered that I wanted that proof before I would grant your request to appear by Zoom.
I don't know.
It would have been as simple. It would have been as simple as, is she in the hospital?
I don't have all those details. Mr. Gillis can answer that.
Well, counsel, this is your client and you're asking for this on behalf of your client. Mr. Gillis, is your grandmother in the hospital?
Yes, ma'am.
Okay, so it would have been something as simple from the hospital indicating your grandmother's name and that she's currently there. And so why
that could be possibly a HIPAA violation, Judge. Because the grandmother would have to provide the permission for the court, or the court would have to subpoena it or order it for the hospital to release that information. So I was a HIPAA compliance officer when HIPAA became online, Judge. So these are the issues that Okay, so then I understand. I understand if he became detained himself, it's an issue.
Perhaps his grandmother could have given some permission that she could have said, yes, you can just to say my name's at the hospital, something of that nature. I'm not asking for a diagnosis. I'm not asking for any of that. Nor was it going to be disclosed anywhere else other than for this court to confirm the reason why Mr. Gillis was requesting to not be in person.
Your Honor,
because as you can imagine, I'm not given honest requests or information very often. I'm not suggesting that would be from you, but perhaps your client wasn't being honest with you.
I understand. And I impressed the point on him that he needed to be here today. And he said it just didn't have, I went through my due diligence with him. I'm satisfied. I know that that's not good enough for this court sometimes, but I didn't know what else to say. At this point, I have 2 other court hearings that I'm already 2 hours late for, Judge. I'm standing in a room for AOI's here, Frank Murphy. I'm prepared to move forward with a waiver on this case if we can do that, Judge.
Mr. Gillis, why is it that you couldn't be in person in court today?
I just didn't have a ride to come back.
You knew this court date was today, correct?
Yeah, but this was unexpected and I was not expecting for this to happen.
Yeah, it happened over the weekend, Judge.
I understand that medical situations arise. Your grandmother's in the hospital?
Yes.
Okay, and so your presence was required?
Yes, because that's my grandmother. She's actually probably not going to make it. She's actually probably going to die because she's unconscious in the hospital right now. She actually fell down the stairs and broke her neck. and I'd hate to say this live on YouTube because it's my personal business. So it's not just like she stubbed her toe or anything like that. It's actually something serious, Your Honor.
Sir, I'm not suggesting it's not, and that's why I wasn't being specific with that, because I have the email from your attorney. And then counsel, you were going to appear in person, but then at the last minute, you requested to appear by Zoom also.
Yes, at that point, it became clear that this morning was going to be as hectic as it is now. And I'm sitting here at 11 o'clock, still not done with my 9 a.m. docket. I've been to Southfield. I've been in Oakland County Circuit. I've been now at Frank Murphy, and I was scheduled to come to you, and I have to be in Warren at 1:30. It's just one of these days.
I do remember the days of private practice and having to be in 15 places within 2 hours.
Yeah.
I do,
Yeah.
I understand that. So then when we're selecting a date, then as you did make mention in your email, perhaps you should have not agreed to this week.
Understood.
Because the court, when we have these matters set in person,
Things are.
with Zoom, sometimes it gets to be taken advantage of, so that's why we have a pretty hard line rule regarding all that. But in any event, Mr. Gillis, you heard what your attorney indicated regarding your preliminary examination,
Yes,
and you understand that you do have the right to a preliminary examination, and it must be shown that a crime was committed and probable cause exists to charge you with that crime.
yes,
And you also understand that by waiving your right to your preliminary examination, that you will be bound over to circuit court on the charges in the complaint, correct?
yes,
And you've received notice of those charges, correct?
yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No,
All right, and I just wanted to make it clear that, what Mr. Anidu, where it says the defendant, attorney, and defendant, I'm just going to indicate via Zoom, okay, on the signature line.
Sure.
All right, the court will indicate that examination having been waived, defendant is bound over to circuit court. You are to appear for further proceedings, you are to appear in circuit court on July 6th. I'm sorry, July 5th. At 9 a.m.
Right.
Council, as far as I know, they're still holding dockets on that day. So
Okay.
we haven't been told anything different, and that would be on the charge of the complaint.
Okay.
Anything else?
No, thank you. Bye now.
All right, thank you. Good luck to you, Mr. Gillis.
thank you.
All right, bonding conditions are continued. Off the record, confirm the testimony you must give be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed on the warrant.
On October 18, 2023, approximately midnight, a tandem car of Officer Tyler Grote and Officer Alexander Stapkis were patrolling the area of 4th Street and 4th Avenue in a fully marked patrol vehicle and fully marked uniforms. They observed a gray Jeep pass by their vehicle and did a routine check of the license plate and learned that the vehicle had no insurance registered to it. Officers activated their overhead lights and the vehicle continued to travel northbound on Fort, eventually stopping at Fort LeBlanc. Officers made contact with the driver who admitted that she had a revoked license. The driver was identified as Amanda Lynn McFadden. However, Ms. McFadden did not produce any vehicle information or driver's license. It was all verbal. Officers asked Ms. McFadden to exit the vehicle and requested consent to search the vehicle and her person, which consent was provided. However, prior to that, she did appear nervous, appeared to be sweating per the officers, and reached immediately for her purse. Officers asked consent to search the purse. Locating in the purse were 2 small, tiny cellophane bags with a white powdery substance, which was field tested positive for propane. And also in the purse was a prescription pill bottle prescribed to another individual with approximately 17 pills in it, which were all some form of a hydrocodone per drugs lab. Ms. McFadden, from what we can tell through maps and law, does not have any prescriptions for hydrocodone and acetaminophen. That's it, Your Honor.
All right, thank you. Upon examination of the complaining witness, I find that the offenses charged were committed and there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Attorney Corey Westmoreland, appearing on behalf of Ms. McFadden. Ms. McFadden, would you please state your full name for the record?
Amanda Lynn McFadden.
All right, thank you. And counsel, as to the arraignment,
At this time, Judge, we are prepared to waive a formal reading. My client stands mute.
the court will waive the formal reading. Mandy, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Correct. Yes.
All right. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, I do, ma'am.
All right. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on October 26th at 9:40 a.m. And counsel as to bond.
Yes, Your Honor, I would like you to know that Ms. McFadden is a resident living in Dearborn Heights. She's currently employed at Tarago Restaurant. She is mother of two, ages 13 and 7. She is not currently on probation. She has no other pending matters out of any of the court. She has no history of absconding from any honorable court. And after speaking with her at length this morning, she did assure me that she would be appearing at all future court dates. I just respectfully request that all that be taken into account when assessing the bond that we have for Ms. McFadden.
All right, and detective, would you like to address bond?
Just due to the status of her license, not to operate a motor vehicle unless the license is legal. And then just to assure a presence in court, $500. And no drugs, no illegal drugs unless prescribed.
Okay, and man, you live in Dearborn Heights
Yes.
and you drive down to Trenton every work?
I do.
And have you ever failed to appear in court for any reason?
No, ma'am.
You're not out on bond? I'm sorry, is she on bond in another jurisdiction?
No, she doesn't have any pending matters that we're aware of.
All right, given the nature of the charges, and the criminal history of Ms. McFadden and the safety of the public, the court's going to order a $5,000 10% bond. In the event you post bond, man, you're not to possess or consume any alcohol or drugs that are not prescribed, and you're also not to drive a motor vehicle. How do you get back and forth to work?
My parents live next door, so my mom can take me.
And do you not have a license from the prior two alcohol-related convictions?
Correct. I was in the process of going in front of a panel. I had to go and get an evaluation and that before I can go in front of the panel.
All right, we'll see you back next week. Thank you. Have a good day.
Thank you, Judge.
All right, thank you. All right.
Nice day, Your Honor.
Thank you as well. So off record for a moment. Who did the other two in custody? In the matter of the city of Wyandotte versus Dustin Powers, 232252.
There you go.
All right.
Stephen Floyd, P36827. Here we have Dustin Powers.
Thank you. And sir, your name for the record, please.
Dustin Powers.
All right, thank you. And counsel, today's the date for the arraignment as your client is in custody.
Yes, Your Honor. With respect to the arraignment, I've had a chance to go over this with my client. He's waiving the formal reading of the complaint and stand mute to the charges. I did have a chance to go over with him his advice of rights, indicates to me that he understands that.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. We will schedule this matter for a pretrial on October 31st. At 10:45. And as to bond counsel.
With respect to bond, Mr. Powers at age of 43, this is apparently his first run in with. He has certainly no pending case. He's not a situation of parole. There's no criminal history that I saw in his file. He has no criminal history. And as such, he has never failed to appear at any part of the court proceeding, because he has no criminal proceedings. Taking that into consideration, we ask the court to set
What?
a nominal bond.
Okay. You're more quiet than Mr. Westmoreland. All right, and sir, you're not currently on probation or parole anywhere, are you?
I'm sorry, what?
Are you currently on probation or parole anywhere?
No,
Out on bond in any jurisdiction?
no.
Where is it you work?
I applied for disability 4 years ago.
Okay. Okay, and there was apparently an accident?
I'm not clear on that, Your Honor. There was a complaint, apparently an acquaintance of his, there's no charges pressed. Some kind of disturbance with an acquaintance of his.
Okay. All right, the court's going to indicate a $2,500 10% bond, not to possess or consume alcohol or drugs unless prescribed, based on the nature of the charges.
I'm being charged with.
Operating while intoxicated, sir. Your attorney indicated that you understood what the charges were, right?
Yeah, but you're saying that.
I'm saying what? What was that, sir?
What is going on? Like, is that all I'm being charged with? Is drunk driving?
Yes, it appears as though there were no charges for whatever occurred with the individual that had the road rash on their lane. So that doesn't appear to be a charge. It's operating while intoxicated. And the court issued a $2,500 10% bond. One of the conditions, sir, is you're not to possess or consume any alcohol or drugs unless prescribed. And then
Okay.
your next court date's October 31st.
Okay.
Okay?
Thank you.
All right, thank you. Any more questions? I guess not.
Thank you.
Thank you. Okay, and then we have Mr. Davis. Mr. Lopez, Mr. Davis. Okay. On the record for a moment, do you know what's going on with the exam that's scheduled at Elevated? Jeremy?
The first exam, first turn, Sprinkle just showed up not too long ago. Bobby put the defendant, the attorney, and the rate in the
Okay.
position.
All right, we're going on the record in the matter of the state of Michigan versus Todd Davis, 232204.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, John Goldthorpe, P 30758, on behalf of Mr. Davis. Mr. Davis, would you please put your name on the record?
Todd Davis.
All right, thank you. And today's date scheduled for the pretrial and counsel.
That's correct, Your Honor. Your Honor, I've had discussions with Mr. Davis as well as with the prosecuting attorney. It's my understanding, Your Honor, that in return for a plea of operating while intoxicated first offense, the driving while license suspended second, as well as the operating while intoxicated second notice would be dismissed. Also, Mr. Davis would plead guilty to the open intoxicated misdemeanor charge. I discussed these with Mr. Davis. I discussed with him his potential liability, both with respect to his sentencing with respect to this matter. I've also discussed with him his constitutional rights, and I've also discussed with him any administrative proceedings that may occur dealing with his driver's license. All that said, Your Honor, I do just hope the court may accept this.
All right, please raise your right hand. You solemnly swear from the testimony you're about to give this is going to be the truth, the whole truth, and nothing but the truth.
Yes.
All right. And sir, I asked you the amended charge of operating while intoxicated first offense. How do you plead?
Guilty.
And you've gone over your advice with your attorney, correct?
Yes, Your
And in
Honor.
fact, you signed that document.
Yes, Your Honor.
You also understand by entering into plea, you'll be waiving some of those rights, specifically your trial and appellate rights.
Yes, Your Honor.
And you also understand the possible penalty for entering into your plea, whether this court, any other court or administrative agency.
Yes, Your Honor.
You also, and so knowing all that, you still want to continue with your plea. And has anybody promised or anything, threatened you or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, any immigration issues?
No, Your Honor.
All right, and counsel, you can please order your client.
Thank you. Mr. Davis, on October 9th of 2023, were you in the city of Wyandotte?
Yes.
And did there come a point in time when you were operating a motor vehicle as such, backing it out of a drive?
Yes.
Did you come in contact with the Wyandotte Police Department at that time?
Yes, I did.
And when you were speaking to them, first of all, did they ask you to step out of the car?
Yes.
And during that investigation, did you feel sobriety tests?
Yes.
And you took those tests, correct?
Yes, sir.
And at some point in time, did you take a breathalyzer test?
Yes.
And are you aware of those results?
Yes.
And was were the results 0.12 and 0.08?
Yes,
I
sir.
believe it's the third one, somewhere in that range as well. And while in that motor vehicle, did you have an open bottle of tequila?
Yes, I did.
And satisfied, Your Honor?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and we'll schedule this matter for sentencing. We can do November 15th, counsel.
Thank you, Your Honor.
You're here that day. All right, so you have and we'll do that at 9:30.
Okay.
And sir, you still have the alcohol title on, correct?
Yes, Your Honor.
All right. Bond and conditions are continued. Please have a seat over probation. Somebody will be with you shortly.
Thank you, Your Honor.
All right, thank you. All right,
Thank you. Thank you.
thank you. All right, have a good day. Everyone, yes.
Yeah.